Welcome again to another episode of the League of the Genuine Conversations with me, Fred Muwema. Every Friday, we are discussing matters to do with counterfeits, matters to do with fakes. As we all know, this is a big issue that remains in our midst, and we need everybody to come behind this effort to make sure that we kick counterfeits, we kick fakes out of our midst. Last week, we handled a hot topic. We handled the issue of COVIDEX. We were not able to have Professor Ogwang on the show. We are still not able to have him. I am sure you are all aware that he has announced that he will not be doing any interviews, media or otherwise. So we are unable to have him, but in his place, we have a very suitable substitute. We have a law don here, an expert, among others, in intellectual property, a dean of the School of Law at Mukono University, none other than Dr. Anthony Conrad Kakooza. You are most welcome to the show.
Thank you, Fred. I'm glad to be
Doctor,
here.
I'm very happy to connect with you again because your father, the late Professor Kakooza, one of the luminaries of law, was my first teacher, actually, at the law school.
It's wonderful.
And I remember I used to come and visit your home because your sister was my friend Bernadette.
Yes.
But I don't remember seeing you. Are you Professor Kakooza's son?
Yes, by then, of course, I was much younger, so I'd hide behind the curtains.
You are hiding behind the curtains and doing mischief.
Yes.
But it's a good reconnection because the time we were at the university studying law, it was those were the good days. It's good to reconnect this way to see that his son now, Dr. Anthony Kakooza, has followed the father's footsteps, and you are here to help us understand a very important subject, intellectual property and so on. Complex. They think that is for the elites, people who went to, who read so many books. But in the discussion that we had last week, there was a lot of feedback. People are not clear on this whole hula baloo about who made this drug, who owns it. And some people were even saying, isn't it the role of the government? Why are you bothering Professor? Why are you bothering the brand owners? Why are you defaming them? Some even were saying, why are you defaming them? And yet, Doctor, the purpose of this show basically is to promote awareness and understanding about this subject of counterfeit. So we are hoping that in the next couple of minutes with you, you'll be able to unpack and help our audience, the public, to understand more and more about this subject. Let's start from the point of COVIDEX. Let's just go straight to COVIDEX. COVIDEX, intellectual property, we are lost. How do you connect the two?
Okay, thank you again, Fred, for having me here. It's a pleasure. Before we jump into COVIDEX, just to clarify, I'm no longer the dean of the Faculty of Law at Uganda Christian University, so I handed over deanship.
You took something bigger.
I don't know if I'd call it bigger, but I did my part and moved on, so that I still
okay.
teach there as well as at Makerere University. So, yes, as you've mentioned, I'm an intellectual property lawyer, and when we talk about intellectual property law and how that comes into the picture with COVIDEX, intellectual property is about the creativity of the mind. So if a person like Professor Ogwang goes into a lab and uses his mind to come up with what we now call COVIDEX, then that's his creativity, and that's hopefully or assumably his intellectual property because he has created it. So that's the connection between intellectual property and our understanding of COVIDEX, that COVIDEX is an intellectual property. The big question now is whose intellectual property is it?
But Doctor, I had the interview of Professor Ogwang, and he said that his concoction is a mixture of plants which are common to the areas of, he actually mentioned some part in Teso called Wusuku, and some other parts in the forests. It may not be clear to many people who may not have a legal training. How can you claim that some plant you pick from the forest or somewhere and you squeeze juice out of it, becomes your property.
Right.
This is community property.
Yes. It's a good question. So for starters, the different types of intellectual property laws. And what we're looking at here is something related to patents, pharmaceutical patents, because that's where it would fall. Pharmaceutical patents.
So what's a patent?
Okay. Patents relate to man-made solution to a technical problem of which you get a protection as someone who has created that man-made solution. It's, if you see that there's a problem in place, my people are dying, as Professor Ogwang was saying that I used to cry out, our people are dying of COVID. And then he says that there's this thing, there's this plant, I can mix this and this to help them out. That's the technical solution he's bringing on board to solve the existing problem.
So that's a patent. Can you give some examples of common patents we use at home?
Oh, there are quite a number. Let me start with what would probably have in this room right now. The lights around us started with someone called Thomas Edison coming up with a light bulb. In any case, history shows that he may not be the owner of that he borrowed ideas from left, right, and center. But Thomas Edison came up and said, let's create this solution. Our people are using lamps, but I can create something called a bulb. And when he created that as a solution, he got a patent. The patent is basically the protection you'd have for what we globally now have as 20 years. That for the next 20 years, we would say, because this person is the one that came up with this solution, we will respect that he owns the monopoly of the market. Time. Yes. As he allows other people to understand how it works, so that once the 20 years pass, everyone anywhere will be able to produce the same thing.
That's how we have been able to have mass production of, for example, automobile.
Yes, yes, because the first automobiles came in 1900 and on and on. The first people that had them, Mercedes and who was the Daimler, when they got together, they had those protection. In the beginning it was 16 years, but eventually it became the current 20 years that we have as the
So our Kira motors that we have here is because of basically what you're saying, the doctrine of exhaustion.
Yes.
That you have been allowed by the law to utilize.
So now with Kira Motors, interestingly, they would not get patent protection because what they're coming up with, electronic versions of cars and all those things, it's no longer novel. So now it's a good question you're posing. To get a patent, there are 3 requirements that you should bring in place. That what you're coming up with as a technical solution is novel. No one has ever done it anywhere. It's really new. Everyone is hearing about it for the first time. So in the same way, Professor Ogwang would say, yes, we've been passing these trees, but no one knew that we could get to extract all these things, put them together, and come up with this solution. So it has to be new. Secondly, it has to have a non-obviousness to it, to people who are of that field. Scientists would say, yes, we can see this, but we didn't think about it. It wasn't obvious to us. So you have to pass that non-obviousness test. And thirdly, it has to have an industrial applicability. It has to be able to fit into a certain industry where they'll be able to use it. So when you have those 3 elements, then you get patent protection. Is industrial
applicability the same as it must be able to have a commercial?
Not necessarily, because I could give you one example. You probably currently have or have had, I remember seeing in a Mercedes-Benz. So Mercedes-Benz at one time took in a new patent from an American who had invented a light that was applied within that Mercedes, that as you're turning the car, the technology senses that this car is turning and then the lights turn ahead of it. Instead of moving with the cars, the lights would turn fast so that as you're turning, the lights really show you.
Yeah.
So he had the patent, but the commercial side of it failed. The market did not warm up to it. So, and that helped us, when we were studying about this, it helped us to realize that you can have something that's patentable, but it does not necessarily mean that the market will warm up to it. It doesn't have to necessarily be commercial. All it has to have is the novelty, the non-obviousness, and the industrial applicability, but not necessarily the commerce connected
the commerce of it. So,
yes.
COVIDEX, is it novel?
Again, another good question. Now, I would say yes and no. Why no? Because we have a Professor Ogwang who comes up and says, I got this extract Ugandese and whatever else, the scientific terms, he mixed plants which are in existence. He talked about his mother had been teaching him about how you mix all sorts of herbs. So probably people have been using these concoctions for quite a number of years to heal common flus and common colds. So to that extent, it wouldn't be. But I would say yes now against, well, the first bit is the no, that it wouldn't be novel if people have been doing this for a while. But if you come in with an extra chemical element in it that is new, that is less than 12 months old in having mixed this, then the novelty is there. Because the Industrial Properties Act, which protects patents, so we would put COVIDEX under that, says that for something to be novel, it shouldn't have been used for the past 12 months. Or if it has been used for the past 12 months, it should have been for experimental purposes only.
But if you experiment and heal people, like the man was telling you, I gave my friend, he healed.
Yes.
I gave so-and-so, he got off oxygen.
Yes.
So what? If I'm healing people, I may say I don't care about your law, 12 months.
The 12 months is necessary. If he wants to go for patentability, he would have to apply, he would have to fall under the law. He can't avoid it. Yes.
But you are saying that novelty is connected to adding some chemical. I heard you saying something like that.
Yes.
But professors told you that this is purely herb. Are you saying that the law discriminates against novelty based on herbs? There must be a chemical?
There's a historical context to that. We are talking about herbal medicine, and we're talking about...
Can you patent herbal medicine?
Yes, you can. You can patent herbal medicine because at the end of the day, it's still medicine. And all medicine under the earth, Panadol, all those things really come from herbs. They come from nature, of which when these people go into the labs, the scientists, they extract the chemical out of that leaf or plant or whatever it is. They understand the chemical formula and then start producing en masse.
Chemically, not herbally.
Chemically. But they start with the herbal side, understanding the herbal side of it. And then they go on to do the chemical side of things. So there's that connection between the chemistry and the herbal thing. So there's this, one of America's first millionaires called Rockefeller. He became a millionaire out of petroleum extraction, the oil industry and the like. And he discovered that you can actually get drugs out of petroleum extraction. And the best way he would keep up with his philanthropy as a billionaire and the like was to push aside people who were benefiting from herbal medicine at the time. This was the early 1900s and the rest. So, because people in the US and across the globe, the Western world, were relying more on herbal medicine, he felt that, let me learn how they use this herbal medicine and start funding medical institutions and medical schools across the globe to do the research, understand the chemical side of this herb, so that eventually we will not need the herbs, but we'll just understand the chemical formula and push aside the herbs. To him, it was keep me as a billionaire, but start discouraging the use of herbs because we have the chemical alternatives. But at the end of the day, it's still the same thing. So because he was the one funding the medical schools to that effect, now when we see all these people out of pharmaceutical institutions and medical schools saying, please disregard the herbs, take the medicine from the pharmaceutical companies, it's because that's the mindset that started from that historical perspective.
So somebody can say that it has a capitalistic
there is definitely
thing to it. Actually, I'm just reading your article here.
Yes.
The article, for those who didn't read, I'm sure it went viral, this one. It was of COVIDEX, the politics of intellectual property rights, and one man's meat. But somewhere, I see something you say here. Let us not forget the fact that COVIDEX is branded as 100% herbal medicine. I would be hard-pressed to find a doctor of modern medicine advocating for herbal medicine. And then you go ahead to explain Rockefeller. So, and you are a visiting professor of so many international universities. Illinois?
University of Illinois, Cornell Law School.
Now, so for you, are an agent of the Rockefellers. You are here to make sure that our indigenous professors or herbalists are prevented from gaining patent protection. What do you say to that accusation?
Okay, I wouldn't take it in light of that, yes, I do subscribe to these foreign institutions which are still funded by the Rockefeller Foundation.
Yes.
But
which don't like Hubble Medicine.
Which some of them don't like Hubble Medicine. But then again, in this day and age, 2021, many of these institutions are more subscribed to the freedom of expression and understanding how freedom of expression works. So yes, they respect that. In any case, when I was doing the research and I fell upon the Rockefeller information, it was while I was at Cornell, which is a big institution that still gets funding from Rockefeller Foundation, but it allows for researchers to disseminate the information about
and share
these things. Yes, and this is the information I'm sharing. So there's a balance today, like I said in 2021, that yes, if you subscribe to modern medicine, that's fine, go ahead. But there are those who subscribe to Hubble. Why I say there's a good number of people that subscribe to Hubble. Within the World Intellectual Property Organization, of which I've done quite a number of consultancies in traditional medicine, traditional knowledge, and cultural expressions, they have come to appreciate that there's so much of intellectual property that is intertwined with traditional knowledge or traditional medicinal knowledge. Especially now that we're on the topic of COVIDEX. When I was growing up, would get this common cold and flu. And my father, who, as you said, was a law professor, would get these leaves. I don't know if it was a mango tree leaf or from other kind of fruits, and he would boil these leaves.
A professor?
Yes. Yes, he would boil these leaves and take us to drink this stuff. Very bitter stuff, but it would cure the cough. So he understood that there's a specific leaf and extracts out of it that would help to cure the cough. And organizations like World Intellectual Property Organization are now realizing that there's something we need to tap into, what they call Hubble and the nature, and see what is it that's protectable there and what is it that isn't. Now, what would not be protectable, and what is even clearly mentioned in our Industrial Properties Act, is that if I just walk across my lawn, pluck a few leaves from a specific tree, chew upon them, and I'm cured of a particular ailment. That is not intellectual property, because it's just nature that I've picked directly. But if I get that leaf, boil it at a certain temperature, add this, add that,
package it,
I'm using my creativity. And that's what Professor Ogwang is doing here. And that's where the intellectual property comes in. And under organizations like WIPO, World Intellectual Property Organization, they would call that traditional medicinal knowledge associated with genetic resources. The genetic resource is the leaf. If you use it in its natural form and just chew upon it, there's no IP to protect.
I saw Pastor Seba chewing some leaves at his farm.
Yes.
So there's no IP
There's
there.
no IP there. But if you've picked it and added another leaf from this plant, added another from here, and offered to other people, and they say, wow, you're curing us of COVID, then you now start thinking of intellectual property or of traditional medicinal knowledge, depending on
how do we make what you are saying, because it might sound technical for many people. Many people are really just interested in healing, that the thing works.
Yes.
But what is it they have had? They have had things like, oh, now NDA has said, don't offer this thing for sale. We have not approved. People are wondering, this NDA serves who? If there are people who can testify and say, I have healed, who is NDA to say, I have not healed? So can you walk us through a bit, through licensing of these drugs and so on? What's the legal regulatory regime?
So we have to appreciate that our government is there to serve its people. And it comes up with regulations for the purposes of an orderly society. If every man under the sky, man and woman under the sky would just say, oh, I've come up with this cure. Remember the lady who said she had this soil. She was told that if you go and lick this soil or drink.
In Masaka.
Yes, it will cure HIV/AIDS.
HIV.
And people were flocking that side.
And they chewed enough soil.
Yes. And did they get the cure? I don't know. I didn't follow up.
But with Professor Ogwang, people have cured.
Yes, there's a
so
cure.
it's different. Maybe it's not a good example.
This is one of few case studies coming out, his being one of them. But we do need to appreciate such regulation to create some sense of order, that if someone comes up and says, I have this concoction or invention and it's meant to cure this, let it go through the regulatory process of approval, which means clinical trials. Does it work? Because we're not only looking at whether it works. We want to also see if there are any side effects. There was this stories coming out that, oh, by the way, pregnant ladies should not just quickly grab COVIDEX because it may affect the baby in the womb and the like. So we need to have all these studies undertaken before people just rush into these products. Nonetheless, there's also an exception that comes in of emergencies, and the law also provides for such emergencies. That yes, as clinical trials are being done, if the initial clinical trials, as they're going through, really, there's in the initial ones being like he was talking about 2 or 3 people have been cured, and that's okay, then you would allow for people to start taking in this product as the trials also continue, because you don't want en masse negative reactions at the end of the day. And the negative reactions can come a week later, 2 weeks later, who knows? That's why clinical trials can even last a year or
But doctor,
2.
what is more en masse than us having AstraZeneca here, which we were told is still on trial, it might cause a clot, but it's spread all over Africa.
Yes.
How come NDA approved that? This is what the people are saying, that there appears to be different standards for Professor Ogwang and different standards for what is approved by certain people.
Yes. Well, NDA, apart from reporting to government, also has certain policies that it has to adhere to that go all the way up to the World Health Organization. So it has to tick up some boxes on all this.
Can't the World Health Organization be wrong?
It can. I mean,
and Professor can be right?
That is also a possibility.
Yeah, so if there is a probability that it can be wrong, I saw some very nice video that Professor Ogwang put out, how to use COVIDEX. I saw it on YouTube.
Yep.
Last night when I was preparing for this show, I went back to reference. And YouTube said it had been pulled down because it does not meet certain
medical policies.
What is happening
YouTube.
here?
Yes. And of course, there have all been all these reactions that, okay, YouTube is now listening to World Health Organization telling it, remove this. And the big farmers have spoken because they prefer that people go with their products as opposed to COVIDEX. There are all these allegations, if I may call them that, they may be true.
No, but they may
false.
not be allegations. See how they handled Trump. For the longest time when Trump was a nuisance, when he was the president, when he held the power in the US,
yes,
Twitter, all these guys could not listen because he was the president. The moment he was shipped out of the White House, they shut him down without, I don't know what kind of hearing, or they just shut him down. So it looks like these big companies probably are following some clue that we don't follow, we the ordinary guys. They are not maybe following the public interest.
I mean, there are many concerns here at play. One, there's this issue of, can anything good come out of Africa? It's one thing. But we've had African scientists who go and work for the big companies abroad. So probably one of their fears is, this is something coming out of Uganda. Have they really done all the necessary tests? We can't be too sure. So we wouldn't want a professor to be telling people how to use COVIDEX on YouTube, which is seen across the globe. 7 billion people would rather put this down until we get a confirmation from our stakeholder down in Uganda, which is the NDA, that this is really good to go. And because of the way many believe things were rushed, that at one point NDA was saying, first hold on here, clinical trials are necessary, and then professors presented all the documents, which they later on accepted. World Health Organization and all these other big stakeholders still feel things should go a little bit slower. So that's to that extent where companies like YouTube would say we don't want to disseminate information that we're not yet so sure about.
Well, for the ordinary person, they really don't care so much about what you the big guys will be arguing there. For them, if they took the concoction and it worked, for them they are happy. Now, what we are hearing again, I saw in the papers, now people are fighting over the ownership of this thing. I hear there is Barara University.
Yes.
They say they own it. In your article, you actually mention it. On the one hand, there is something I saw here. We are together on the Uganda Law Society Intellectual Property Platform.
Which I heard as a convener.
Yes, you are the convener. I'm your member there. This is what somebody posted. I didn't see you responding to it, but somebody said here that the facts that Professor Ogwang, inventor of COVIDEX, that the invention was done at Entebbe, not Mbarara University. It's on record and in writing that Mbarara MUST rejected his request to use the university facilities and laboratories for his trials and tests. And they give the reason that they didn't want to afford the name of the university or to connect the name of the university with such an embarrassment. That this is a letter from the Deputy Vice Chancellor. And then they said, now it's surprising and interesting to see the very university that didn't want an embarrassment to its name to claim rights to the invention of Professor Ogwang and his company, Jenna Products. Now, I will not go further. I want you to speak to, if you will, this issue of ownership. First of all, you've told us the thing grows the way it wants. Nobody gets it. Nobody gives it pesticide. It just grows. Now, all of a sudden, we are being told a whole university is fighting one individual about ownership. What is this thing about ownership with intellectual property?
Now, there are quite a number of things there, quite a number of things with regards to ownership. Let me start with the provision under the law. Under the Industrial Properties Act, and I make mention of that in the article, if a scientist like Professor Ogwang is employed by a research institution, which includes a university in this sense, Mbarara University of Science and Technology, to teach and research, and the contract stipulates that all the intellectual property out of his work would be owned by the university, wouldn't be having these battles, because the contract would be clear. So that's what the Act says, that absence of a specific provision in a contract, the employee would own the work, the invention.
So it would be commissioned work?
Yes. So you start with the contract. What does the contract say? If the contract is silent and this person invents, then he should take what he invents. But there are many other nitty-gritty other things to consider here. I had the opportunity of going to the website of Mbarara University of Science and Technology, and I was a bit disappointed. I looked at their policies. They don't have an IP policy, or at least if they do, it's not on their website. So I said, where else would they talk about IP? Either human resource policy or research policy. They do have a research policy, but it has nothing to do with intellectual property. It's about teaching loads and all those kind of things. So I looked in the human resource policy. The research policy is 13 pages long. Very brief, not helpful. Their human resource policy is 100 pages long. I browsed through it. Again, there's nothing about someone who invents or anything. It's really talking about employee issues and workloads and all those kinds of things. So then it's really vague when it comes to ownership issues there. So now putting aside the documentary perspective.
But it's not vague. It's clear from how your review that they did not support.
They did not consider any of this.
That's
they
what
did
you're
not.
saying.
And yet this is Mbarara University of Science and Technology. Ordinarily, an institution of science and technology should think about the intellectual property that comes out of them and should really factor in ownership and things of that nature, which they did not do. So outside of what the documentary issues are, they would turn to what is on the ground. So they employ this person to work for them, and he works for, there's that institution under Fiber something?
It's called Farm Biotract.
Farm Biotract, yes, thank you. So that Farm Biotract is owned by Mbarara University of Science and Technology, and it's
a center, Farm Biotechnology and Traditional Medicine Center.
Exactly. So it would be interesting to see whether his contract said anything about what he comes out of with under that center and who would own it. Maybe that's what they're trying to hang on to. I don't know, I haven't seen his employment contract. But there's this talk about him going to them and saying, hey guys, I've come up with this thing. And they were saying, no, please don't involve us in the Hubble stuff, that will embarrass us. That letter alone would kick them out. That's one thing. And secondly, the other thing that would kick out MUST is because the professor says he came up with this at his own place in Entebbe, but not Anbar. So he used his own resources. They may try and argue that, oh, but the people he was working with there are our employees, because he has also said in his interview, Desert Island Disc, that he worked with people who are employees of Mbarara University. But where were they working from? The cases that I've studied that are about employee-employer ownership disputes, you have a person who is a scientist, he works for an institution, comes up with an invention, but he did it on a Saturday at home. The institution would lose the case there.
But Professor, Doctor,
Yeah.
Here we have two samples.
Okay.
Can you show me which one comes from Mbarara? Where does that thing come from?
Okay, so both of them have COVIDEX on them. I would first of all give a disclaimer that as someone who doesn't
Are you saying
work,
Mbarara there?
No, there's nothing here that says Mbarara University. There's nothing that says Pharmatex or whichever.
So this comes from
It stays Hubble. Hubble. So that's the company
of
Professor Ogwang. Yes.
So until we have the COVIDEX labeled by Mbarara University, we have no basis to say that this is a product.
On the face of it, we would say that this is owned by Jenner. They're the ones producing it from their place on Entebbe Road.
So we should ask MUST to bring their bottle so that we look at it also and see.
Yes.
Maybe it's the same or it's different.
Not only their bottle, whatever information they have to keep claiming that this is theirs, they should produce it, because that's how intellectual property ownership works.
But now, Doctor, the challenge we are facing is this. As Mbarara and Professor are fighting over who owns which bottle and how and who squeezed the juice out, the counterfeiters are smiling all the way to the bank.
Yes.
How is the fight between MUST and Professor Ogwang helping the counterfeiter?
The counterfeiter is happy. He's, as you've said, they're smiling all the way to the bank, because when they, first of all, they don't really always have to look out for an opportunity of fighting owners, two big elephants. For them, as soon as they see a market, that there's an opportunity here, they'll grab onto it. Remember when the first lockdown happened and we're all being pushed to sanitize? There were counterfeit small bottles of sanitizers, and people wouldn't notice the differences here. So here, this is creating a big, huge opportunity for counterfeiters. It's not just because the market is huge, everyone is talking about COVIDEX, not just Uganda, but Rwanda, DRC, and all those other places. But the people who would be helping us to understand who really owns are fighting amongst themselves. So counterfeiters say, this is a grand opportunity. Let's produce en masse, and people are just focused on, oh, it's healing me. And the owners, whoever they are, instead of guiding us to please go to this specific place, buy from only such sources, or buy from a product that looks in such and such a way, are more involved in who really owns, the counterfeiter will make the fake one and start selling.
So do you think the law can play a role in arbitrating that dispute, in helping the public to receive this wonder medicine without the confusion and drama? Can the law play a role?
That's a good question, but it's hard to really answer, because when we talk about the law, we're looking in terms of the Trademarks Act right now. Because when you look at a product like this one, ordinarily, the professor, while he tries to haggle through getting protection for the contents, whether he can get a patent, and that's something we'll need to talk about, he would at least get a trademark to enter into the market. The trademark is the one that associates a mark with the source of a product. That if I go to a shelf in a pharmacy, I would know that, oh, this bottle that has this mark comes from Jenner Hubble. So there we turn to the Trademarks Act. What does it say? Trademarks Act tells us that in order to get a trademark, you'd have to register the mark that is not associated with the product. So the first question is, will they allow him to register a mark that says COVIDEX to heal COVID? It's suggestive, and suggestive marks cannot be given. It has probably even become generic. That's another issue. On his side, he would probably argue that it has become secondary. If a mark develops a secondary meaning, like the mark being COVIDEX here with the picture of a COVID, whatever, the whole thing, then he would say it has acquired a secondary meaning. Everyone identifies with COVIDEX. Maybe the trademark registrar would hear him out on that.
One bottle has a name.
Yes.
Another bottle doesn't have a name. One bottle, the cover is slightly different from the other.
Yes.
In terms of trade dress, and actually one is lighter. This is lighter than the other one.
Yes.
How important is trade dress in trademark protection?
Trade dress is part of trademark protection, and trade dress can also go under even copyright protection. It looks at how you arrange either a product or even how you arrange a place. For instance, Apple, the ones that sell the phones and the like, they have trade dress protection for their stores, their Apple stores, the way they're designed. McDonald's restaurant have trade dress protection for the way the restaurant is designed. So in this sense, the trade dress would be the way the whole thing has been designed. So it's part of trademark, it's part of copyright, it even also involves industrial design protection. All that can fall under trade dress. What appeals to the eye of the consumer is what goes with trade dress. Intellectual property is quite interesting. I've studied cases to this extent that the way what a man looks out for in his shopping is different from what a woman looks out for. That's why women take longer shopping than men. A woman will go into a store, let's say basic supermarket, and we'll look at this thing, we'll get it, put it back on the shelf, get another, put it back on the shelf. She's studying, analyzing. A man, and I've seen it for myself, I walk in, 5 minutes, I grab what I want, put it in a tray, I go home, and then my wife is like, you bought the wrong thing. I'm like, oh my God, I didn't realize. So that's where we would fall here, that I'll just quickly grab and later on realize I've bought the wrong COVIDEX, because the confusion is there and the likelihood of confusion are also there. And those are the problems with trademark infringement. As long as you see a likelihood of confusion, then you're infringing. So one of these is different from the other, as you've spelled out. One has a smooth cover. The other has a straight kind of cover. The other has a sharp top. The other has a smooth top. Then, when you go down, one has the words Jenna, the other doesn't have. A man or anyone would just quickly grab. I have a person at home, he's almost dying, he can't breathe. You just grab the wrong one without realizing. Another person would try and analyze and say that, hey, wait a minute. From the ones I've bought previously, they're different from this bottle. So there's a difference here. The trade dress is different. So this is where people like Professor Ogwang start losing out. The people who are paid to rubbish through plastic, and you see them packing up all these bags with plastic, they don't just take to throw away. They take to people who are counterfeiters, and they will start repackaging their own mess, which they sell out. And we never take note of these differences because we are that desperate lot who want to heal someone or treat someone, or we are really rushing into that quick remedy without taking the difference.
Doctor, I've always investigated the question of product liability in these countries of ours. And I know that we don't have much of legislation in these areas. That's why we don't have product recalls and so on. Yeah. But don't you think that in terms of product liability, Dr. Ogwang has come out and said, this is my product. In terms of product liability, he has a duty to come out and tell the public which of these is his bottle.
Very good
Is
point,
it the one with Jenna or the one without Jenna? Don't you think NDA, rather than coming to shut down and so on, let them bring the man.
Yeah.
They have now stopped him from talking to the media.
Exactly.
Can he come and tell us? He has a duty, I believe, to explain which is the correct one. Right now we have 2, 3, 4 different products on the market, and we are being exposed. We are groping in the dark.
The law is really vague on counterfeits. It doesn't help as much. Yes, there are provisions on counterfeit, but they're not that helpful. We need to go beyond the law. If I am the producer of the product, as Professor Ogwang is, we had him on Desert Island Disc saying that he has placed a certain kind of code on his bottle.
QR code.
The QR code. Institutions like Uganda National Bureau of Standards would also come out and say, we have looked at it, we have certified. They put a certification mark. Not just something that is pasted there, but maybe engraved within the bottle so that someone would look.
He said they will do something within the mold.
And then huge publicity campaign. Go on the radios, WhatsApp is huge, send out all these messages and tell people that please, if you buy a product that does not have X, Y, and Z, you're buying the wrong product. Because people who, like I said, just grab and take home without knowing what they're taking would not know any of this information.
Because supposing somebody gets harmed,
who do they go to?
After taking one of those products,
yes.
Legally, who do they go to?
That's the question. Who do they go to?
Will MUST, for example, Bara University be ready to take up claims for fake COVID, for the COVIDEX, or they will only like to take the profit or benefit?
There's this communication, I don't know how true it is, that came out of government when they had that, people were paying 100,000, 200,000 for vaccination, and they were told, you're on your own, you got from the wrong places. You should have gone to the right places. So institutions like MUST would now come out and say, no, please do not come to us. We're not the ones who told you to go and buy from the common man down there. And in the same case, Professor himself was saying, please buy from licensed pharmacies. But how can we tell which is a licensed pharmacy or not? The law stipulates that every pharmaceutical shop or whatever it is, pharmacy, should have a display up there showing that, yes, we've gotten approval, this is our certificate and the like, but these are also forged. So at the end of the day, the liability aspect is a very hard one to make, and that's why counterfeiters easily get away with it. They're the so-called mafias, that they will make the fake ones, sell them, you end up falling sick and dying, and you can't even catch up with them to know who to go for.
Now, Doctor, at the risk of complicating an already complicated issue, we would like to end on a note that gives some direction.
Yeah.
Because the way we have dissected the issue, we have just thrown it upside down. So people must be very confused.
Yes.
What do we do now? Now, I think I will pass the baton to you. Professor Ogwang is a scientist. Even you are a doctor of science of law, so you're a scientist as well. Can you, as a scientist, give some direction to the public? Should they buy this thing? Should they not buy it? Should they wait for some announcement from somewhere? Or should they just pray and continue taking it? We need to give some direction on this show.
Yes, we need to give direction. I think the direction starts with National Drug Authority. As things stand right now, National Drug Authority has approved COVIDEX. So let National Drug Authority tell us which is the genuine COVIDEX. Why I'm saying NDA is because the maker of NDA has been shut. He's been gagged. Don't speak to the public anymore and things like that. So we can't keep going to him. He can't talk. So NDA, which has approved, so tell us that the genuine product looks like this, and it can only be bought from
the genuine
X, Y, and
product
Z.
you registered in
Yes,
NDA
exactly.
is one of these.
Yes.
National Drug Authority, can you come out and tell us, did you approve this one or this one?
Yes.
Did you approve the sharp beak or the blunt beak?
Exactly.
Did you approve the one with the general marked bottle on? I think this is the information the public
Yes.
needs.
And just shortly before our interview started, I got one of those unsolicited text messages from Safe Uber. They always say, oh, please buy from us and this and this. So the Safe Uber was now saying, we can deliver to you COVIDEX.
Which one?
So that's another thing, that are they delivering the genuine one or the fake one? So all these other e-commerce related service providers, Safe Uber and the like, should know if they're delivering as they say, where are they getting it? Are they getting the fake one or the proper one? Because there can be a contributory liability element here that would connect them to that. What you delivered to me instead caused my person to pass on, to die.
One of the accusations leveled against the elites is that, look, we have knowledge, we are so detached from the common man, we just speak too much English, and and that therefore enough is not being done to make sure that the community benefits from our knowledge. For example, in the area of IP, the concept of geographical indications is one that really intrigues me. A geographical indication being an IP protection given to a geographical location. For example, Champagne, they produce champagne, but it's from a region of Champagne. Basmati rice is from the Himalayas, and you'll never call basmati rice unless it's coming from the Himalayas. Yes. Now we here, we have a lot of geographical indications, which we do not exploit.
Uganda waraji.
Why do we call it Irish potato? I mean, it's unique to that area of Uganda. We have the Ankole cow with its long horns. What can you as a law don tell the viewer out there that these things are relevant and can have meaning to the local community? We have a lot of geographical indications, maybe even COVIDEX could be a geographical indication. How can we exploit them? What is the hope here you're giving?
The main problem we have, as you've mentioned, is a lack of awareness. In my 16, 17 years of teaching intellectual property, awareness has always come across as the biggest problem, that people do not know what's around them or how to utilize it. geographical indications or geographical indications protection as an area of intellectual property relates to two unique features. That one, we have something that originates from a specific place, and two, that it's unique to only that place. Once you have that, then you apply for geographical indications protection. We have the Geographical Indications Protection Act of 2013. You get 10 years protection, which is renewed 10 years indefinitely, so it can last forever. So people are, first of all, not aware about this existing law, many of them. Secondly, they use these things. Backcloth, for instance, I'm currently part of a project where we're trying to see if we'll interested stakeholders in turning Mabugo backcloth into a GI protection for Uganda.
For us, we leave it for which doctors?
Exactly. We have the thing of, oh, yes, we have this cloth, let's leave it for you. And yet there's so much potential. There's a company in Germany that is called Bactex and picks backcloth from Uganda. They pay a few farmers here. It's owned by a German and a Ugandan lady. And this Oliver Haynes and his wife, Mary Haynes. And they've made so much money out of backcloth. Not
it's
just
used even in the automobile industry.
Yes,
for the
it's through their company. They supply the automobile industry. It's even in the UK. We have companies there that are using it for fashion industry and the like, benefiting. So how we connect all that? We need to look, and the stakeholders here would be government stakeholders. Uganda, URSB, Uganda Registration of Services Bureau, yes, would come in as at the forefront. Local farmers, look at all these different stakeholders that know that, yes, we have rice that is unique to Mbale, Tirini region. We have coffee that is unique to specific Arabica areas. Yes, and we have potatoes that are unique to Kabale. If we can show that they have these qualities that cannot be associated from any other region, as Professor Ogwangs was also saying, there's Ugandesis and all these specific products that make up COVIDEX that you only find in Uganda, Kenya, and the like. If they're unique to ours and they're not the same as in Kenya, then why not get geographical indication protection?
Ethiopia was able to do it with Nescafe.
Exactly. And they first had a battle,
big battle.
Yes, which they eventually resolved when it was realized that those specific qualities I've mentioned, that yes, you have something that's specific to a region and it has that unique quality, then GI protection should be given.
So those who love Nescafe, for every spoon of coffee that you put in your cup, you're giving some money to Ethiopia.
Yes.
Okay, but at least it's good that you have been able to lay it out that, look, these opportunities do exist. We would like to ask you, as a law don, we have one of the major crises we have here, education. I don't know whether it's the curriculum, or it's the lecturers who have an issue, or it is the students, or it is the culture of praise and celebrating. These days, even when a kid graduates from, leaves nursery, from baby class to upper class, there's a party.
Yes.
What is happening to the education? We have a lot of fakes. Yes. What do you attribute this to?
I think it's quite a number of things, first of all, but it's mainly that our current system was not meant to cope with 1,000+ students. Remember, when we studied law, yourself and myself, we had only one law school in the country. Now I think there are 12. As someone who has been a law dean, having been dean for 4 years at Uganda Christian University, in fact, it's Uganda Christian University that started pre-entry. That's if someone is joining law school, let them first do an exam. And this caught on Makerere, LDC, Bishop Stewart, many other universities followed. But now
you've scrapped it.
It was scrapped from LDC. UCU, Makerere, and all the law schools still have it, but LDC removed it. And yet LDC sacks all these different people from the different law schools. When we studied, I think in your year you were about 40 students at LDC.
Yeah, we were not, at the university we were 40.
Okay.
LDC, I think we rose to about 50 because there were some matures who came.
But that was a manageable number. When I was at LDC, you can imagine. Exactly, for the whole country. When I was at LDC 20 years ago, we were 100 students in my class. Now there are 1,400 students. So they're first of all taking in huge numbers and it's suffocating them. Secondly, of the 12 or so law schools that are feeding into LDC, some are teaching genuine quality education. Others, it's more of a profit, that bring your students on board. We don't want bad marketability, because if we have so many failures, they won't apply to join our university. So they just bring on everyone. They're looking at the profit bit. And then now that there are no checks and balances as they go to LDC, you have all these packed and pushed into LDC to handle that.
So you think the commoditization of education is the
biggest problem? And what has been trying to help to remove, or at least try to put that in check, which was the pre-entry at LDC, was removed. So the commoditization has sucking into LDC and is also going to be affecting it, that you have 1,500 students who are admitted there, and many of them have not been properly trained from where they're coming from. You can't check that at LDC. The failure rates will still keep going
So
up.
what's the way forward with our education? Because for me, the other problem I have is that we have a lot of emphasis on paper qualifications. We do not emphasize problem-solving skills, for example, for the students.
Yep.
And there is this tendency to think that once you have gone to school and your degree or your qualification, you've finished the education. It's like you stop there, and then, whereas education is continuous. So what do you think should be done to stop these fakes that are coming through the education system?
Yes, it's good you're asking the right questions to the right person. Just 2 weeks ago, I wrapped up a consultancy project with National Council for Higher Education. They had hired me and a colleague to come up with standards for the LLB and a proposed diploma in law nationwide, so that every institution in the country that is teaching the Bachelor of Laws, or that wants to teach the diploma in law, should have certain minimum standards that they should follow, so that we start looking at quality. Don't just teach for the sake of teaching, but have you ticked up all these things? The National Council, in partnership with the Law Council, starts visiting annually, as they're already doing, all these institutions to see, how are you teaching? What are you teaching? And in those standards, we emphasize a hybrid between the theory and the practice. Students should not just come up with understanding what's out of paper, but let them do clinical studies, go out and relate what they've picked from the classroom with what's out there in practice, so that they're better grounded. And if they can get that from the 4 years of training and take that to LDC, then we'll be having a better lot of students. And it would be one way of tackling the commoditization of teaching of law in those law schools that don't care about quality.
So how sure are we that this is not going to be another white elephant project? A lot of studies, reports, white papers are put and stacked up there, and they gather dust.
Well, when we presented these minimum standards, we had pretty much all the stakeholders in legal education in the country. We had representatives, including the director from LDC was present. We had deans of all the law schools. We had Professor Sempewa, who heads the legal education under the Law Council. So they took this in, gave their comments. We're going to buttress them and fine-tune them further, and that's what we present now to the law schools, to say that, hey, this is what you really need to do. And then the follow-ups follow. On an annual basis, National Council would have to visit with the Law Council to see that they're actually doing this. So that
Your final word,
students.
Doctor. Ugandans like cheap things, Ugandans like counterfeits. I can tell you with the fact, whether they do it consciously or unconsciously, perceptibly or otherwise. What you as a law don who understands intellectual property, what is your message to Ugandans who maybe don't understand this issue of counterfeits, or they do understand it, but they don't know the dangers? What's your message to them?
It goes back to awareness. As I said, it's not just we are not aware about intellectual property, but we're not aware as to which is real, which is fake. So when we go out to buy those products, we should do extra diligence. We should be able to see that, am I really buying the right product? Where am I buying from? Whenever you go into a quick market and say, let me get this from someone, a border guy who got it from another guy who got it from another guy, then I'm opening myself up to get, likely to get a counterfeit product. So we should be making sure we buy genuine products from the right places. Then it's not just the consumer. We should also place it upon those that supply these products to send out dissemination campaigns and let people know what to look out for, what are the key things that I should really be looking out for to know that I'm buying the right product. And if people listen more to these campaigns on the radio, on TV, or through their WhatsApp messages, then they will be able to start telling what is counterfeit and what is genuine.
Fantastic. So that has been Dr. Anthony Conrad. I didn't know you're called Conrad. Kakooza, a law don, a doctor of science in laws with a bias in intellectual property, real estate, cyber law. I didn't ask you about fake news. There is no time. But that ends our episode. He has helped to shed some light on matters to do with the ownership, the intellectual property rights of COVIDEX. His suggestion, we agree, that the public requires to know, since there's COVIDEX on the market, which is the genuine, which is the fake. We have 2 bottles here, and his suggestion, which we buy, is that the NDA should come out and help you to identify which of these is correct. And I think the NDA should come in the company of Professor Ogwang, so that he should tell us which of these 2 bottles is actually the bottle in which he packs his genuine product. Because consumers have a right to consume safe products, and they have a right to know what is safe and what is not safe. So until the next episode, this has been the League of the Genuine Conversations. We would like to end here by saying, don't be fake, buy and sell genuine products only.